He held them for everybody. We've had women even say that when they went in front of the judge, whether it be Mullins or Kraft, both I think this happened with, the judge granted them house arrest, but Ben decided he didn't like that person. So he wasn't going to interview them or even let them do house arrest. So even though the judge had ordered these people were allowed to be released on house arrest, Ben just took it upon himself to no, I'll get to him eventually. And then he just never did get to him. There were several people he did that way, men and women. You think he's the only one? You think that isn't a common practice? I would hate to see how that jail. Remember, old Muff Diver, his old lady. I mean, are you joking? No, we're not joking. No, unfortunately, no. Indeed, he eventually wielded his power against her, filing a false criminal complaint against Adkins to cover up their arrangement. That act put Adkins back in jail, and nobody gives a damn. Nobody gives a damn that she was falsely arrested, that she had to lay another night on that concrete floor. I want to see Matt Butler's head lay on that concrete floor. I would love to see these people who act like they are so much above the law just have to spend just one night in jail. I think they should probably have to do that as part of their training. Spend one night in the drunk tank just to know what it feels like. That's my own personal little thing there. I'd love to see that. Oh my goodness. Let's see. Thus, Fields' promise to help Adkins and his later circumvention of her home incarceration requirements in light of these stakes and in conjunction with the sexual activity are strongly indicative of coercion. You reckon? Adkins was a victim of Fields' adjudicated crimes. So, the argument in favor of consent is thin gruel. A reasonable jury could also conclude that evidence of Adkins's subjective experience indicates a lack of consent. Explaining that subjective intimidation was evidence that the encounters were not consensual. Adkins testified that she engaged in sexual conduct with Fields because it was the only way that she thought she would be okay on house arrest without paying. She also testified. Where was that pulled from? The deposition? Whose, though? Adkins testified that she engaged in sexual conduct because it was the only way that she thought she would be okay on house arrest without paying. She also testified that the sexual contact was her only option at the time, and that she did what she thought that she needed and had to do to stay out of jail. And she felt scared and terrified because of the situation. Still, other evidence also implies coercion. Where and when their interactions occurred suggest a coercive atmosphere. Adkins and Fields met after hours in a judge's private chambers in the courthouse. The county jail was in the basement. In the first instance of physical contact, Adkins testified that Fields forcibly kissed her and grabbed her and kissed her on the mouth. Such physical contact is an unmistakable marker of non-consent. Fields also bestowed gifts on Adkins, such as the cigarettes he bought to console her. Fields was criminally charged and pled guilty. Yeah, man. To third degree R and third degree S for his relationship with Fields. Good. Signifying non-consent and the role of his official power in these crimes. Taken together, a reasonable jury could easily conclude that the present coercive factors rendered the sexual contact between Adkins and Fields non-consensual. Let's see. To overcome the presumption of non-consent. I'm really confused at all this talk about consent when we already know that these women are not, like, they can't consent. If he is their supervisor over a house arrest program, how is there any consent? I am just blown away by this. Blown away by that part of it. And it seems like the court has, I guess, taken that consent off the table. Is that right? So it doesn't apply? Does anybody know? Does the PREA, does the PREA not apply here? I know it wasn't raised by Sabrina's lawyers. And I was told that she was told PREA didn't apply in this case. So that's very confusing to me. To overcome the presumption of non-consent, Fields points to evidence that Adkins admitted to making flirtatious comments to Fields and engaging Facebook messages and photographs with Fields that were sexual in nature. And she texted with Fields on a daily basis for a period of about 7 months. What about the grooming? Like, these were things, these were actions. See, that's where I'm totally confused. Because, well, I'm not really confused. I'm upset because the way that the interviews went with Matt Easter, it was all, the narrative was, oh, you saw an opportunity. And I feel like the court, this judge, sees it exactly the same way that Matt Easter saw it. We're just going to put it all off on the girls. They saw, instead of it being like, okay, well, we have to play the game. You know, it's not like she could have sat there and not engaged in the flirtatious comments. He started hitting on her first. It wasn't like she saw Ben and thought he was so irresistible and wanted to start flirting with him. That is not how that happened. And I think that this is just a shame. I think it's a shame. They are putting the blame on Sabrina is what they're doing. And it doesn't matter. Listen, it does not matter. If Sabrina wanted to go to old Uncle Bill on her own, without any house arrest, supervisor, jailer, without any help of intervention or association with the jail or house arrest or anything. If she would have wanted to go sell herself to old Uncle Bill up the road, she could have done that, and that would not be sex trafficking. Not really.